Mr. Summit.
My Lords, good morning. Just before your Lordships hear from a learned friend, we've put up on your Lordship's desk a small clip of some cases which are relevant to the issue your Lordships raised about the relevance of appeals in a foreign jurisdiction where fraud is raised. I'm happy to deal with that. We've obviously provided a copy to my friend. I'm happy to deal with that in reply briefly, and then if my friend wants to respond, of course, he can. Or your Lordships can hear from me now. I just don't want to obviously interrupt.
I wonder whether, from Mr. Phillips' point of view, it would be best if you took us briefly to the bits that matter.
Certainly. So, my Lords, first, Appellant and Oppenheimer, which was a case which was referred to below. If your Lordships have the authorities bundle, please. What your Lordships see at page 2 is that there was a claim brought before the District Court of Tiflis in Russia. Your Lordships see that on page 2, about the first 3 lines under claim 1. And then in paragraph 2 over the page 3, your Lordships see there was an appeal against that judgment to the High Court in Tiflis. And then the allegation was in the defence that the High Court and the District Court were misled. But if your Lordships then go into the judgment of Lord Justice Brett and my Lords, page 12, he begins with regard to an action brought upon a foreign judgment. The whole doctrine of fraud is English and is to be applied in an action that's purely English. Your Lordships would read the end of that passage over the page 13, but then it's the next paragraphs. So far as the doctrine as to fraud was hardly disputed, and then the critical bit for present purposes is his Lordship says about 15 lines up, I will assume that in the suit in the Russian courts the plaintiff's fraud was alleged by the defendants and that they gave evidence in support of the charge. So the assumption is that the very issue of fraud was raised in both the original, the District Court, and the Appeal Court. And his Lordship goes on, I will assume even that the defendants gave the very same evidence which they propose to produce in this action. Nevertheless, the defendants will not be debarred at the trial of this action from making the same charge of fraud and from adducing the same evidence in support of it. So obviously I rely on that. And there is a point, before I just go on to Vidala and Laws very briefly, of course, in this case, the issue of fraud was not raised by Mr. Drelle before any of the appeal courts. And therefore he's entitled to take advantage of the proposition of law that he's not bound to raise it, and that the fact that he doesn't raise it doesn't debar him from pursuing the issue of fraud here. And for your Lordship's note, your Lordships see that is a fact is correct at supplemental bundle, pages 88 to 89, where both experts refer to that. The second case, my Lords, is Vidala and Laws. It's another appeal case. That's in tab 2 of your Lordship's bundle. And your Lordships see at page 16 that an action was, in the third paragraph on that page, an action was brought in the Messina Court, Royal Tribunal of Commerce of Messina. And then there was an appeal affirming that decision at the Court of Appeal in Palermo. And then your Lordships see 5 lines up from the bottom of that page, the defendant put in a statement of defence in which he raised the defence that the judgment of the Italian courts had been obtained by fraud. And the response to that, your Lordships see at page 18, please, in the penultimate paragraph on that page. In his reply, the plaintiff pleaded, so the plaintiff, obviously the person who's obtained the judgment by fraud, the plaintiff pleaded that the allegations as to the speculative and gambling transactions were made by the defendant in the action in the Italian courts and were then gone into and adjudged against the defendant. So another example of where the issue is raised before both courts and the appeal courts, against the party seeking to impugn the judgments in this jurisdiction, and there is no bar. And the Court of Appeal in Vidala follow Abulov. And then, my lords, lastly, Jet Holdings and Patel, which was briefly mentioned yesterday, and I was right, the fraud there was to do with threats of violence. And if your lordships go, please, to page 35 of the bundle, Lord Justice Staunton refers to the Dicey rule, bottom of the page 40, then 44, about impeaching a judgment for fraud. 45 deals with public policy. Over the page, please, my lords, then 46. And his lordship says, on the threshold of the argument for the defendant is the point that the foreign court's own view as to whether the judgment was obtained by fraud isn't conclusive or indeed relevant. Deputy Judge seems to take a contrary view. And then his lordship says at E, where the objection to enforcement is based on jurisdiction, that's Rule 43, it's to my mind plain that the foreign court's decision on its own jurisdiction is neither conclusive nor relevant. If the foreign court had no jurisdiction in the eyes of English law, any conclusion it may have reached to its own jurisdiction is of no value. To put it bluntly, if not vulgarly, the foreign court can't haul itself up by its own bootstraps. Logically, the same reasoning must apply where enforcement is resisted on the ground of fraud. Rule 44. If the rule is that a foreign judgment obtained by fraud isn't enforceable, it cannot matter that in the view of the foreign court there was no fraud. And then his lordship refers to a competing rule, but then there's reference to Abulov, lordships, and Vidal at the bottom of the page. He then deals over the page of 37 with a submission made by Mr. Burton, as he then was, as to the distinction between procedural fraud and substantive fraud. And then again at E, my lords, on that page, once again, one would expect the foreign court's views would logically be neither conclusive nor relevant as to the propriety of its own proceedings. If the English court considers the foreign court didn't observe the rules of natural justice, for example, rudi audi alteram partem or nemo iudex in rem suam, why should it make any difference if the foreign court thought of observing the rules of natural justice and so on? And then that's it for that supplemental bundle. And then I would just lastly, respectfully, refer you.
Can I just pause there?
Yes.
I understand why it said that a foreign court on whom the deception had been practiced, to use those words, its own views would not logically be neither conclusive nor relevant to the propriety of its own proceedings. But if you have an appellate court on whom it is said the fraud was not being practiced, or in fact, in this particular case, which was not said to have been itself biased or acting fraudulently, why is that irrelevant?
Well, because, as I submitted yesterday, the judgment that is relied on here is the judgment which was obtained by fraud before the first arbitrage court. What then happened is there was no taking of that point by Mr. Drelle before the appeal court, and he wasn't obliged to take that point as a matter of English law, and he's therefore entitled to raise the specific point of fraud of the arbitrage court before this court as to impeachability. That's what the law entitles him.
So would your argument be different if what the Court of Appeal had done was make its own order, and that's what it was seeking to be enforced, as opposed to affirm the order of the court below?
If the Court of Appeal had conducted a rehearing...
Well, assume that's right, and I understand you don't accept that. But,
no, but
but assume that to be so.
Yes. But I'm following your lordship's... I'm answering directly, I hope, your lordship's point, which is if there was a fresh judgment from the appeal court and there was no challenge as to bias of that court, and it's that judgment which is then relied on for the purposes here, then it wouldn't matter what had happened in the lower court.
But it would, in your submission, if there was no allegation of bias in the appeal court and there'd been a rehearing, but what in fact happened was that rather than making a fresh order, the Court of Appeal simply affirmed the first instance order.
Yes, that is exactly.
That's a critical distinction.
That is, yes, it is, and that is exactly my submission.
Thank you.
And then, my lords, in Owens and Bracco, which we looked at yesterday quite several times, which your lordships find in your lordships' bundle, authorities bundle at tab 11, in that case, their lordships, as you will know, upheld the rule the common law rule in Appellant, and in particular, forgive me, there was a reference, your Lordship sees in the speech of Lord Bridge at page 159 to Appellant and Oppenheimer, and specifically at page 160, the part of the judgment of Lord Justice Brett, which I read to your Lordship, but it is the critical bit, because it's where Lord Justice Brett proceeds on the assumption that the issue of fraud was raised in both courts, so that it doesn't matter. And then your Lordship sees that the Darwin laws is also referred to as well. And those two decisions of this court are still the law. The House of Lords said that it was too late to start changing the law, and there's been no proper inroads to them. Lord, that's what I wanted to say, and I'm grateful for your Lordship's giving me time.
Thank you very much.
And to my friend.
Mr. Phillips.
My Lords, maybe start with 6 propositions. First, a petitioner brings a petition on a debt. Second, the debt does not need to be a judgment debt, whether on an English judgment or a recognised foreign judgment. A petitioner did not need a judgment to petition under the Bankruptcy Act 1914.
I think we're going to need to go more slowly.
Oh, I'm so sorry.
So I got as far as it doesn't have to be a judgment, whether an English judgment or a recognised foreign judgment.
And then, if I may carry on, the petitioner did not need a judgment under the Bankruptcy Act 1914.
So is this third proposition or part of?
It's part of 2, my
Part
Lord.
2, yeah.
And that continues to be the position under the Insolvency Act of 1986. There was a difference with bankruptcy notices that I will show you. That's the second proposition, and it's the longest. Third, it follows that a petitioner does not need to be able to enforce a judgment in order to petition. Fourth, the debt just needs to be a debt within the meaning of section 2672B. Fifth, a debt will arise on the judgment. Some debts will exist prior to judgment. And sixth, and finally, in the case of a foreign judgment, the question is whether there is a bona fide dispute that the judgment can be impeached.
Sorry, can you go back? What was 5?
5 was a debt will arise on the judgment. Some debts will exist prior to judgment.
So I've written down a debt can arise prior to judgment. Is that correct?
Yes.
So is that's the proposition?
The fifth proposition is a debt will arise on the judgment. So on the foreign judgment, a debt will arise when the judgment is given.
It's given.
Yeah. And some debts will exist prior to there being a judgment.
And thereafter independently of the judgment, or is there a doctrine of merger?
In relation to English judgments, there's a doctrine.
Yes, but in relation to foreign judgments.
In relation to foreign judgments, I needn't go there.
All right.
And so, my lords, the sixth was, in the case of a foreign judgment, the question is whether there is a bona fide dispute that the judgment can be impeached.
Sorry, and is that question, sorry, that does its status as a debt depend upon that proposition? Is that the
Well,
question?
yes, my lord, we'll go back to, the lordship will be well familiar with this, Mann and Goldstein. If there's a bona fide dispute as to the debt, then the petitioner is not a creditor, because the debt, as a matter, in the context of a petition, the debt doesn't exist if it is bona fide disputed.
That's contrary to recent Court of Appeal authority. That nobody's cited to us.
I am wholly unaware of that.
Okay. That's a decision of Lord Justice Newey and myself. In Khan and Arvinder Singh, I'll just give you the reference.
Thank you.
2023 EWCA Civ 1119.
Well, in which event?
Or at least I think it may be anyway. I mean, it depends exactly how you put it, but I think you better have a look at that.
No, I understand. I was obviously just picking something up from out-of-date law. But if there can be a bona fide dispute and there's still a debt, then the way in which you can't petition is obviously slightly different.
Yeah, I think the point we make is the point that's made in a number of cases, that a bona fide dispute about the debt doesn't destroy the status of the debt. It's just as a matter of practice.
You can't petition.
Well, as a matter of practice, the court will, yes, strike out your petition or send you off to the normal courts, but it doesn't destroy the underlying debt. It still is a debt. It's just one that you should go and establish for the purposes of procedure elsewhere.
I understand, my lord.
So, I mean, that point may actually be in your favour.
It is in my favour, my lord, and I will review
But you better have a look
Proposition
at that at some point.
6, but I don't need to go as far as that in the case of Proposition 6. The point that I was teasing out in Proposition 6 is, to put it another way, in order to petition, the question is whether the creditor has a foreign judgment, whether there is a bona fide dispute as to whether the foreign judgment can be impeached.
The gist of the point is that that's the only relevant question.
That is the only relevant question.
And that's really your Proposition 6.
Yes, that is the only relevant question.
Yeah, that is the
No, it is the only relevant question, and that is what I was hoping to tease out of Proposition 6. And I'm grateful to your lordship for drawing that case to my attention.
Well, it may or may not be relevant. I mean, as I say, it's just the way you put that proposition before
It's
we
too
clarified it. It was a little bit,
Yeah, no, I understand, my lord. I understand. Could I ask you to take up, go to A88 in the judgment at paragraph 25, please, just to remind you of what Mr. Justice Richards said. And I just want to pick it up 5 lines from the bottom where he says, therefore.
I'm so sorry, could you just give me the paragraph number again?
It's paragraph 25, my
Thank
lord. And I think it's 5 or 6 lines from the bottom, and it's 2 words from the right-hand side where he starts therefore. He says, therefore, the petition debt point involves the question whether the judgment meets the requirements of section 2672B of the Insolvency Act. More specifically, the question is whether the judgment gives rise to a debt payable to ST either immediately or at some certain future time. As a shorthand, I will refer to this as the question of interpretation of the word debt. So he there identifies the correct question. And my lords, if we can just look at 267 at this point, which is in the authorities bundle, tab 3, page 14. Just to remind your lordships, and it's really 2, subsection 2, subject to the next 3 sections. We don't need to worry about that. A creditor's petition may be presented to the court in respect of a debt or debts only if, at the time the petition is presented, and then it identifies the amount of the debt, or the aggregate amount of the debts, is equal to or exceeds the bankruptcy level. To the debt, or each of the debts, is for a liquidated sum payable to the petitioning creditor or one or more of the petitioning creditors, either immediately or at some certain future time, and is unsecured. And then one gets to inability to pay debts, and that is then setting aside a statutory demand, and that is then dealt with in section 268. The point is that what is required is a debt, and the conditions the debt must satisfy are set out in subsections 1, and particularly subsections 2A, B and C. There is no condition that the debt should be a judgment debt. There is no condition that the debt should be enforceable as a matter of common law.
There's a requirement that it must be payable immediately.
Yes. And
As far as relevant.
That is it, my lord. And please, if you would keep 267 available, because I want to come back to it in a moment. My learned friend relies on Rule 45. That really does not alter the language and requirements of 2672.
Okay, well, before we go to conflicts of law and Rule 45,
Yes.
You say there's no condition that a debt be enforceable at common law. So just let's stay domestically for a second.
Yes.
I mean, there's no definition of debt for this purpose in the Insolvency Act.
There is. I'm going to come on to it. There is, my lord. It's in, if your lordship will go forward to page 20 of the authorities bundle, it's section 382. And
sorry. Okay, that's bankruptcy debt.
yes, bankruptcy debt. Well, we're in bankruptcy. So what you get from...
Yes, but the word is not, sorry, the term is not debt. I mean, bankruptcy debt is something that is used separately in inverted commas elsewhere in the legislation.
Your lordship will see when we look at Mr. Justice Chadwick, as he then was judgment in Maxwell, that this definition of what a bankruptcy debt is applies throughout the whole of Part 9 of the Insolvency Act, which includes 267 and it includes 322.
Sorry, I'm making a slightly simpler point.
Yeah.
This definition has in between the inverted commas
Yes.
2 words.
Bankruptcy debt.
Not one.
No,
And bankruptcy debt isn't the expression that appears in 267. So
No.
you're going to have to join the dots for me.
I wonder whether this point is actually going to matter, because subsection 3 isn't bankruptcy debt. I'm not sure that subsection 1 adds anything, does it?
For the purposes of the references in this group of parts, that is precisely the point that Mr. Justice Chadwick was making, my lord.
Except the point is that subsection 3 is really just saying it's not actually providing a definition. It's just saying it doesn't matter.
Present, future, actually.
Present, future, etc., etc., etc. Although, actually, curiously, it does actually, because 2672 makes its own point that you can't. It narrows it. So
It narrows it.
But we still haven't got a definitive, exhaustive definition of the word debt.
Yeah, but for present purposes, what we have got is we have 267, and then, as my Lord Justice Newey rightly points out, and I should have taken you to this first, And your lordship will note bankruptcy debt and liability are the 2 points in the heading, but it says for the purposes of the references in this group of parts, that's the entirety of part 9. It covers 267, it covers 322 on proof, which I'm going to look at shortly. Debt or liability, it's immaterial whether debt or liability is present, future, whether it's certain or contingent, whether its amount is fixed or liquidated, whether it's capable of being ascertained by fixed rules, etc., etc. And the references in this group of part to owing a debt are to be read accordingly. And what that you then read back into 267, if I may respectfully suggest, submit, is that when in 267 it talks of a debt, one has to read into that it is immaterial whether the debt or liability is present, future, and so on and so forth, so that a debt for those purposes includes all of those things.
Except to the extent that
Except to
B
the extent.
says it has
Yes.
to be.
No, that is absolutely right, my lord, and that then ties into a point I'm going to come on to shortly, which is the rules on proof. But I want to come back to these sections after I have explained the position under the Bankruptcy Act 1914, if that's acceptable to your lordships, because it is important. It's one of the reasons why there has been so much confusion over the requirement for there to be a judgment. But can I come back to proof and the definition of debt shortly, please? So your lordships will have seen the judgment at 35 and 36, in which what Mr. Justice Richards said at A90 is that Section 267 of the Act, Parliament has legislated to determine which claims confound the presentation of a bankruptcy petition. It's not left this section to the common law. It's only debts that satisfy the requirements of 267 confound a bankruptcy petition. That is all plainly correct. Now, I want to, if I may, before going to the Maxwell decision, ask you to turn up the Bankruptcy Act, which is in Authorities Bundle 1, Authorities Bundle Tab 1 at page 4. And this is Section 1 of the Bankruptcy Act. And your lordships will know that under the Bankruptcy Act of 1914, there had to be an act of bankruptcy within 3 months of the petition. And in order to get what was a receiving order, the creditor had to be a creditor. So there are 2 triggers. One was there had to be an act of bankruptcy, and 2 is the creditor needed to be a creditor. Now, the importance of acts of bankruptcy, well, there's several important points about them, but one starts by looking at what the acts of bankruptcy were. And your lordships may recollect that this gave rise to incredibly technical approaches, in particular to whether or not a bankruptcy notice was correct. Section 1.1, a debtor commits an act of bankruptcy in each of the following cases. The first is makes a conveyance or assignment of his property. The second is if he makes a fraudulent conveyance, gift, delivery or transfer of his property. The third was if he made a conveyance or charge. The fourth is one of my favourites because it's so wonderfully historic. If with intent to defeat or delay his creditors he does any of the following things: departs out of England, being out of England remains out of England, departs from his dwelling house or otherwise absents himself, or begins to keep house. I love keep house. And then E and G are the only 2 that require a judgment. E is if execution against him has been levied under process and the goods have either been sold or held for 21 days, provided that the proviso doesn't matter. F is a declaration of inability to pay debts, and then G is if a creditor has obtained a final judgment or final order against the debtor for any amount, and execution not having been stayed, serves on him in England or by leave of the court elsewhere a bankruptcy notice, and that was, as I've said, the form of that was very particular under this Act, and he does not within 7 days after service of the notice, in case the service is effected in England and in case the service is effected elsewhere, then within the time limit and so on and so forth, that is an act of bankruptcy. And then it adds at the end, for the purposes of this paragraph of section 2 of this Act, any person who is for the time being entitled to enforce the final judgment or final order shall be deemed to be a creditor who has obtained a final judgment or final order. And it's important for your lordships to have in mind there are two separate things happening in bankruptcy under the 1914 Act. There is the act of bankruptcy, and then there is the creditor's petition. And for that, can I ask if I hope your lordships have a small supplemental bundle of authorities from us, because in that bundle, in tab 1 at page 2, you will find section 4 of the Bankruptcy Act.
I'm sure I do. I'm not sure I do either. Right.
Sorry.
Pardon me?
I've got 3 supplementary authorities. There were some
Oh.
joint supplementary authorities originally. There was the bundle which Mr. Samex referred us to, and then there's another one which in mine just has extracts from the 1986 Act and the
Yes,
insolvency rules.
that I'm going to come on. That I will come on.
But there's
to
another
a bit
bundle
later.
somewhere, is there?
No, it's the first one, my lord.
Oh, I see.
It should be the first one.
Yeah, my mistake.
No, it's definitely not.
Tab.
It's tab 1. It's page 2, and this is section 4.
I'm with you now. Thank you.
Conditions on which a creditor may petition. A creditor shall not be entitled to present a bankruptcy petition against the debtor unless the debt owing by the debtor to the petitioning creditor, or if 2 or more creditors, the aggregate amount of the debts owing amounts to £50. So that was the equivalent of the bankruptcy level at that time. B, the debt is a liquidated sum payable either immediately or at some certain future time. And that will be familiar to your lordships. It's always been there. The act of bankruptcy, this is the third point, on which the petition is grounded, has occurred within 3 months before the presentation of the petition. So there are 2 conditions. One is you've got to have an act of bankruptcy. And the second is that the creditor has to have a claim in respect of a debt that is liquidated, either payable, either immediately or at some future time. They are not the same thing. And my lords, if your lordships still have the authorities bundle at tab 3, page 14, and still have 267, if you just put 267 side by side with 4, your lordships will see subsection 2A and section 4.1 subsection A refers to the debt exceeding the bankruptcy level, which, as your lordships have seen, was £50. And your lordships then see in subsection 2B the same as you had in 4.1b. You then, under the 1986 Act, have the position in relation to bankruptcy notices. Under the 1914 Act, you had acts of bankruptcy. And under the 1914 Act, your lordships have seen 2 of those acts of bankruptcy required a judgment. So, against and my lords, your lordships will have seen that the only form of enforcement under Section 1 of the Bankruptcy Act was in E, and in G you had the requirement of a judgment or a final order. The question was raised yesterday, and I think this is convenient. No, sorry, before I do that, I just want to say in relation to the Insolvency Act 1986, acts of bankruptcy have gone. There is no requirement anywhere in relation to bankruptcy under the 1986 Act for a creditor to be a judgment creditor.
That was the first of the 2 propositions you prefaced this.
Yes, it was.
By, so you've
yep. I hope, my lords, it's helpful, but I attempted to identify propositions that I will make good during the course of my submissions. There is no requirement for a judgment creditor anywhere. Previously it was in relation to bankruptcy notices, but it's gone. The requirement for a debt is now in 267, and your lordships have seen it mirrors what was in Section 4 of the Bankruptcy Act 1914. The point I was about to make was to answer a question that was raised yesterday, which was when the creditor's ability to petition to wind up a company on a debt was introduced. And the answer to that question is Section 82 of the Companies Act of 1862. A creditor has been able to petition on a debt since then, since that Companies Act. So, with that background, can I take your lordships to the...
but without a judgment?
Yes, absolutely, my lord. And it won't be lost on your lordships, but in 1986, the position in relation to bankruptcy moved to, well, I would say to mirror, actually, to the position that one had in relation to corporate insolvency.
Not entirely.
Not
I mean,
entirely.
apart from anything else, you don't need any kind of demand before you present a winding up petition.
No.
But anyway.
No, absolutely, my lord, but moved substantially.
He got rid of...
along that line, and that was in relation to the change from bankruptcy notices.
Was there in the company context a limitation on it being a debt payable immediately or at a certain future time?
That was in Section 4 of the Bankruptcy Act as well.
No, but in the company context, in winding up. Was it originally in Section 82 of the 1862 Act, or in any of the subsequent?
I would be answering off the hoof.
You don't know. It's not necessarily the same.
Reasonably confident, because I've looked at that in the judgment fairly recently, that it's always been you've always been able to present a petition in relation to both current, prospective, and contingent for companies.
That would be my answer as well, my lord.
I'll give you the answer in a minute.
Thank you.
I apologise. Can I take you to Maxwell and Bishopsgate, please, which is in tab 12 at page 167 of the authorities bundle. And the question that arose for Mr. Justice Chadwick in that case was whether you need a judgment for a bankruptcy petition. And what you had was an interim payment order against Ian Maxwell for, I think, £500,000. And if I can start with the judgment at the bottom, 3 lines up from the bottom on 167, where Mr. Justice Chadwick says, the grounds upon which that application is based appear in an affidavit sworn by the defendant on the 21st of January 1993. It is said that the order for interim payment does not create or constitute a debt, or is otherwise incapable of supporting a statutory demand or of founding a bankruptcy petition against the defendant. And if I can your lordships will see that he quotes section 267 there on 168, and if I can go over to 169 and pick up 3 paragraphs from the bottom, the basis of the defendant's application. The basis of the defendant's application to set aside the statutory demand is, as I have indicated, that an order for interim payment made under Order 29, Rule 11 of the Rules of the Supreme Court does not create a debt capable of supporting a statutory demand or of founding a bankruptcy petition. The requirement in section 2671 of the Insolvency Act is that a creditor's petition must be in respect of a debt owed by the debtor to the petitioning creditor. For this purpose, and indeed for the purposes of all the provisions of Part 9 of the Act, the word debt is to be construed in accordance with 382.3, which we have looked at. And he then quotes 382.3. And as your lordships appreciate, that definition of a debt is for the purposes of all of Part 9. Section 267, dealing with a petition, I'm sorry, I'm going off the case just for the moment, is within Part 9. Section 322, in relation to proof of debt, which is in the little supplemental bundle with the bankruptcy section 4 in it. Sorry? Oh, I'm sorry, no, it's not that one, it's the other one. I'm sorry, there's a typo. Sorry. The lordships have a tiny little bundle which has got 322 and Rule 14.2. This is 322, proof of debt. That is also in Part 9, so that 382 applies to that as well as to 267. 322 1 provides, subject to this section and the next, the proof of any bankruptcy debt by a secured or unsecured creditor of the bankrupt, and the admission or rejection of any proof will take place in accordance with the rules, which is why over the next tab I've just put in Rule 14.2, which applies both in the personal and corporate context.
But hang on.
Yes.
I don't have any. Sorry, it's a little bit of a divergence, or just sort of diversion. I don't have any difficulty with the proposition that when you are proving a debt in the bankrupt estate, it doesn't matter whether you have a current, prospective, or continuous claim and all that sort of stuff.
No, absolutely. It's not the point I'm actually dealing with. It actually arises out of something my learned friend said yesterday. So if you'll bear with me, just please let me show you this point. 14.2.1, all claims by creditors except as provided in this rule are provable as debts against a company or bankrupt, whether present, future, and so on and so forth. That's what the rule says. There are then exceptions as to what is not provable, and your lordships can see what they are. My learned friend said that a foreign judgment debt is provable yesterday, and that is correct, but it also follows that if a foreign judgment debt is provable and is for a liquidated sum payable immediately, it is a debt for the purposes of 267, because all the definitions payable immediately, so obviously that condition has to be met.
Does that beg the question?
Yeah.
I mean, to say that a foreign judgment debt is provable doesn't tell you on what basis it's provable. It certainly doesn't tell you whether it's provable as something presently owing or whether it's something contingent.
No, your lordship's absolutely right. It must be presently. It must satisfy the presently owing condition.
Well, it does for 267, but not for 382.
So it could be treated as contingent upon recognition, and that's the point.
I understand the point that your lordships are making. Provability is wider than petitionable debts. But I completely understand that.
I mean, I can quite see, if you could say, look, we know that a foreign judgment debt is provable, and it could only be provable if it were treated as due now,
Yeah.
that would help you with 267. But if the position is that we don't know that that's the case, I'm not sure it helps you.
Well, the point that I was making is that if it is provable and if it satisfies 2672, in other words, is payable immediately, then it follows as night follows day, that it's a debt. It's a petitionable debt.
I'm still not seeing what you get out of the provable debts definition.
Yeah,
If suppose, hypothetically, that it was a provable debt but only because it was a debt which was contingent on recognition,
Yeah, that wouldn't.
then that wouldn't help you.
No. No, it wouldn't help me.
No. And why?
Well,
And why couldn't it be treated as provable on that basis?
Well,
An
that's why-
unrecognised foreign judgment debt.
Yes, but if you satisfy the condition of 267, in other words, the narrower condition, if you can show that it is presently due for a liquidated sum, then it shows you that the definition of debt runs through the whole of Part 9.
sorry, I'm struggling with where you started with all this. Where's the authority that says that without more, a foreign judgment is provable?
Oh, it's my learned friend said that. Yes.
Yeah, but he's not authority.
I know he's not.
So where's the authority that says that? Because that if there was one, it would explain the
Absolutely.
point you're trying to make, I think.
No, I completely agree, and I don't have that.
But
At the same time, it would be quite surprising if it weren't the case.
Yes.
I mean, suppose
But it
any old company becomes insolvent. The liquidator wants to find out which debts he should pay dividends in respect of. You'd think he would want to take into account a foreign judgment debt. The more so if, as I think Section 34 of the Civil Judgment and Civil Jurisdiction and Judgments Act says, once you've got a recognisable judgment, the underlying debt has gone for English purposes. So if the liquidator is going to pay a dividend in respect of the foreign claim, it has to be because of the judgment.
The foreign judgment.
The foreign judgment.
No, yes, absolutely, my lord. Anyway, I don't want to put too much weight on this, but I think your lordships have the point that if a foreign judgment debt is provable and it is a debt for the purposes of Part 9, then if it satisfies the additional condition in 267, it's still a debt. And that was the only point I was trying to get from it. And I think at that point I will go back to Maxwell because I don't want to labour. I don't want to labour what might be thought as a.
I mean, this can't just for my own peace of mind. This can't be exhaustive, though, can it? Because I think it's well understood that foreign revenue claims are not provable.
Well, that's true. That's because there is the gloss in relation.
So there's an overlay over this.
There must be.
In relation to that aspect.
There must be, my lord.
And that's a conflicts rule, what used to be called Dicey Rule 3, and I think is now Dicey Rule 20.
Yes.
Yeah.
And,
So there is a conflicts gloss on this.
yeah, and we will, in relation to foreign judgment debts, we're going to see what it is because we've got the three exceptions.
Yep.
No, I completely understand, and I'm absolutely not trying to labour anything that isn't going to help you. So if I can go back to Maxwell.
But do you accept that even if one adopts what's in 3823 in that very wide definition of debt for the purposes of Part 9, one can't simply transpose that to Section 267 because in both cases there is a conflicts common law overlay in relation to revenue debts?
I would accept that because, my lord, one also has, in relation to foreign judgments, the question of in what circumstances you would impeach them. And that is an overlay, and it's the overlay that we have been arguing in favour of.
Possibly. That may confuse what's your jurisdiction.
Well, I hope
a debt in the first place,
it's a debt.
and then what my lord's described as the practical management
Yes.
of whether you allow the petition to go forward.
Yeah.
But
Yeah.
certainly in relation to some conflicts rules, they qualify what we see in the language of the statute. So I think I've understood you to accept that.
I think that, my lord, I think that's right, because if one looks at, there are a number of cases in the insolvency field in which it's explained, and I'm thinking of Brown Wilkinson, in which it's explained that the insolvency system still works within the existing legal structures. It doesn't just ignore them completely. Anyway, can I go back to the point on Maxwell? Because it's an advocate's worst nightmare is when you think you're making what's quite a clever point that arises out of something, and learned friend says you then find you're spending all your time dealing with that when the more important point is in the case that you were looking at in the first place.
I never make clothes.
Can I go back to 170? And this is, so back to Maxwell, page 170. And if your lordships see, this is the argument of Mr. Girolami. The paragraph that starts, notwithstanding the wide terms in which debt is defined for the purposes of Part 9, Mr. Girolami, on behalf of the defendant, contended that the obligation to pay under an interim payment order does not have the necessary quality of finality to constitute a debt upon which a bankruptcy petition can be presented, and that accordingly it cannot constitute a debt for the purposes of a statutory demand under section 268.
I mean, that's so adventurous I don't actually understand it.
That seemed an optimistic submission.
No comment. It didn't succeed.
No.
But I need to show it to your lordship so you can see that was the first, and then the second, in the next paragraph.
I mean, an interim payment is he says it doesn't have the necessary quality of finality. But I mean, it's sort of like, it's a payment on account of cost, for example.
Yes. My lord, please don't.
I'm not blaming you for Mr.
Girolami's submission.
I'm just trying to understand. Okay,
Yeah.
Right.
No, well, that was the submission.
Right.
That was that submission. Then in the next paragraph, the position under the Bankruptcy Act may be summarised as follows. Section 1 of the Act defined the circumstances in which a debtor could be said to have committed an act of bankruptcy. One such act was the failure to comply with the bankruptcy notice served under 11G of the Act. Section 4 of the Act set out the conditions which had to be satisfied before a creditor might present a bankruptcy petition. One condition at 41C was that there had been an act of bankruptcy within 3 months before presentation. Section 3 empowered the court upon presentation of a bankruptcy petition to make a receiving order. The making of a receiving order would or might lead in due course to an adjudication of bankruptcy, and that's in Section 18. A bankruptcy notice under 11G of the Act of 1914 could be served only where a creditor had obtained a final order or judgment against the debtor. It's common ground, I accept, the bankruptcy notice under that section could not have been served in respect of an interim payment order. That is because an interim payment order is not a final order. It is subject to adjustment or variation at any time during the course of proceedings. And he then sets out the rule. But it does not follow that the obligation to pay under an interim payment order would not have been a debt upon which a petition under the 1914 Act could be founded. A debt which was not a judgment debt could found a bankruptcy petition under the 1914 Act if there was some other available act of bankruptcy, that is, some act other than the failure to pay in response to a bankruptcy notice, upon which the creditor could rely. It seems to me, for example, that an unsatisfied execution in respect of a payment due under an interim payment order would have been sufficient to found a petition based upon that interim payment order under the 1914 Act. that execution by writ of FIFA is available to enforce an interim payment order is clear from the terms of Order 45. And then, so there could have been another act of bankruptcy, and your lordships have seen the various other acts of bankruptcy. And this is one of the reasons why I made the point that the act of bankruptcy does not have to be in response to the creditor who petitions. It could be something independent. The fourth point is then the requirement that a bankruptcy notice could only be served after a final judgment or order had been obtained has not survived the changes made in 1985. And this is the point that is generally understood when one looks at the Maxwell case. There is no longer a need for an act of bankruptcy in the old sense. The requirement under Section 267 of the Insolvency Act is that the debt is a debt which the debtor appears unable to pay. Section 268 defines the circumstances in which that condition will be satisfied. They include failure to comply with a statutory demand. There is no requirement that the debt in respect of which a statutory demand is served should be a judgment debt. A fortiori, no requirement that it should be a debt resulting from a final order or judgment. I can see no justification for reintroducing the old requirements governing the service of a bankruptcy notice into the scheme, which is now based on the service of a statutory demand. It is clear that the legislature did intend to change the law in that respect. So all you need is a debt which the debtor appears unable to pay. The fact that execution could not take place to enforce the debt because it was an interim payment order did not mean it could not be the subject matter of a statutory demand or petition. And my learned friend's proposition, and I'm putting this generally, that for bankruptcy you must be able to enforce or execute on the debt at common law, or that bankruptcy is a form of enforcement or execution, is inconsistent with Mr. Justice Chadwick's judgment.
I mean, whether or not that matters may be debatable. In one sense, it might suggest that the absence of authority showing that a foreign judgment debt could suffice is more striking.
Why?
Well, as you say, you didn't necessarily need a judgment. There could have been a case where a creditor said, look, I've got this debt because I've got a foreign judgment, and I can show an act of bankruptcy by reference to that without relying on G. And there is no such case.
Yeah, well, actually there is.
There is.
I'm going to show your lordship. I'm going to explain. I think it's, is it McGreevy? I think it's McGreevy. But I'm going to come on to that now
Okay.
actually. But there are two important cases in the bankruptcy context that really do tease out what was going on and actually also explain why the Muir-Hunter textbook says what it does. But I need to do that. And of course your lordships will have the submission that the submissions are inconsistent with the 1914 Act, because you only needed it for a judgment for two acts of bankruptcy, and it's inconsistent in our submission with 267. But your lordships have that.
But before we move on,
Yes.
what do you say of importance to this case do we get out of Bishopsgate? How does it help us in deciding whether an unrecognised foreign judgment will give rise to a debt for the purposes of Section 267?
You do not need a judgment in order to have a bankruptcy debt, a debt for the purposes of bankruptcy.
But you do potentially here, if it is the case that the underlying, well, you are relying on the judgment to show the debt. You're not suggesting that anybody should be going into the underlying merits of the foreign judgment. You are simply relying on the judgment, and indeed you couldn't, it seems, do otherwise, having regard to what Section 34 of the 1982 Act, because you have to look to the judgment. So the fact is quite true. You don't have to have a judgment, but here you rely entirely on the judgment.
Yes, no, we're using judgment in two jurisdictional senses. What I don't need is I don't need an English judgment, and I don't need the judgment to have been recognised.
And those are the questions we have to worry about. But I'm not sure why Bishopsgate helps on that.
well, what Bishopsgate shows is, from an English law point of view, you don't need a judgment.
Which we know. But
I will
you
now-
do need a debt.
Oh, yeah,
Here
you
you
need a
say
debt.
the debt arises from the judgment. So the question is, for English law purposes, does the foreign judgment, when unrecognised, create a debt?
Well,
I'm not sure that
let me-
Bishopsgate helps with that.
No, it's dealing with the narrower point. But I'm building up, my lord. There's going to be a crescendo.
Yes.
The point is that when one gets to Rule 51, one gets the debt unless it's impeachable. And that's where we're going to get to, but not...
And I see that, but
This
just
is
going back to Bishopsgate, we know from the Act that we don't need a judgment. So what does Bishopsgate tell us that helps us?
Well, it tells you you don't need an English judgment.
But
And I'm
that
going to
Section
show-
267 shows that. I mean,
Bear
it's
with
obvious.
me, because there have been a number of... This case is unbelievably simple, but there have been so many hairs running around. I have to deal with them.
But this is simply your proposition too, that the debt doesn't need to be a judgment debt, whether an English judgment or a foreign judgment. Is that?
No, it doesn't need to be an English judgment or a registered foreign judgment.
Yes, it doesn't need to be a judgment debt at all, whether English
Well,
judgment
it is
or
it is a
foreign
judgment debt because it's the foreign judgment is the judgment debt. That's the foreign judgment debt is the judgment debt. But we mustn't get confused about the need for an English judgment or an English or registration in England, and that is important. And I'm now going to show your lordships why everyone got confused, and it comes out of acts of bankruptcy under the 14 Act.
You go on. I'll
No,
work
well,
out where you are in due course. I'm still
No,
slightly lost, but
No, well, I
keep
hope-
going with the submissions, and it'll all become clear, I'm sure.
No, look, the proposition I'm dealing with. Sorry, I shouldn't say look. I'm sorry. Sorry, my lord. The proposition that I'm dealing with at the moment is you don't need an English judgment. You don't need a registered. You don't need to get an English judgment on the foreign judgment debt. You do not need to register the foreign judgment. Those are the two propositions I'm in. And the first building block of that is you do not need a judgment for it to be a debt under 267. And Maxwell helps with that. Maxwell also helps because it explains where the concept of there being a need for a judgment, in bankruptcy has come from. It's come from the acts of bankruptcy.
Without wishing to throw further confusion into the wind, I mean, what I get from Maxwell is just confirmation, a comfort blanket, because Mr. Justice Chadwick or Justice Chadwick thought this, that in the purely domestic context, you do not need a judgment to present a bankruptcy petition.
That is the proposition
And
I was aiming at on this.
But it's in the purely domestic context.
Yes.
And it supports the first of the two propositions that you prefaced going to the statute with, that there's no condition that you should have a judgment debt, at least in the domestic sense.
Yes.
I'm still waiting for the second point. There's no condition that it be enforceable at common law, and I think I know where you're going to go for that.
Yeah.
But we still haven't really touched the sort of overlay of foreign conflicts of law.
Not yet.
Right. Okay.
Not yet.
I understand where you are.
Not yet. The next case I want to look at is McGreevy, which is in the Supplemental Authorities bundle. And I think it's in tab 2. I hope your lordships have it. And it actually, as your lordships will see immediately, deals with the enforceable point, amongst other things. So McGreevy is a decision of the Court of Appeal, and looking at the head note, the question was whether an unpaid demand for rates was a debt within the meaning of Section 4 of the Bankruptcy Act, and my learned friend took your lordships to it yesterday, although it is not enforceable by action at law, which we will look at. A local authority may accordingly petition in bankruptcy in respect of such demands. So the question arose because a claim for rates was not enforceable by action in law. That was the problem, which meant the local authority could not get a judgment. It was held it was a debt and the authority could petition. If I can just show your lordships, in the next block, right in the middle of the page, the partners committed an act of bankruptcy by executing a deed of assignment for the benefit of their creditors. So that's the act of bankruptcy. And if I can take you, the other thing I just wanted to point out to your lordships, if your lordships can see, junior counsel for the debtor was Mr. Muirhunter. And over the page, on page page 4, just at the top of the paragraph there must be a judgment debt to form the basis of a bankruptcy motion. And picking it up at 271, which is page 5, this is internal.
Sorry, internal what, two?
Internal 271, sorry, it's 5 in the bundle.
Yeah.
I'm so sorry.
No, I got it.
The first proposition I just wanted to pick up is at the bottom of the whole of the paragraph. The rating authority here are attempting to enforce payment of rates in a manner not authorised by the Rating Valuation Act. And then Mr. Hunter following, and his submission was the liability to pay rates does not constitute a debt. And picking it up at the top of the next paragraph, where he says the Rating Acts impose a liability to pay rates which is enforceable by distress but not otherwise. So those are the submissions made by Mr. Hunter.
And just going back to the previous paragraph.
Yes.
Unpaid rates have not the characteristics of a debt, except that they are a sum of money which a man is liable to pay.
And these are the submissions that were made, my lord, and these are
Yes.
the submissions that are rejected.
But even on his case, is recognising there's a liability to pay.
Yes.
Yep.
Yes. And we'll come on, your lordships will see how the Court of Appeal dealt with it. So we pick it up on page 6 in the bundle. Your lordships see that Lord Justice Somerville read the judgment of the court, and he said that the issue raised by the appeal is whether rates assessed, demanded and unpaid are a debt, and the rating authority to whom the rates are due be a creditor who can petition within section 4, the relevant provisions of which he then sets them out. So there he identifies the issue. And if I can pick it up on over the page where it says the main argument was based on the fact that unpaid rates cannot be recovered by an ordinary action. It was submitted, therefore, that there was no debt within section 4. It is common ground that unpaid rates are not recoverable by action, but it's necessary at the outset to refer to the statutes, and so on. And then, if we can go forward to page 9 of the bundle, which is 275 in the report, and I want to deal with 3 passages, but in the following order. Can I start with "we will now consider," which is in the middle of the page? We will now consider the wording of section 4 and the sections which precede it. Section 1, which sets out what constitutes acts of bankruptcy, provides the following in paragraph F. If he files a debt.
Just before you go, sorry.
Oh, sorry.
You went over the previous page. I mean, there is one point, section 33 makes it clear that rates are regarded as a sum becoming due and payable, in fact.
Yes.
In fact, I think by inference, they're actually regarded as certainly a debt for the purposes of distribution.
Yes. And that's plainly right.
Yeah.
What your lordships are going to see is how they rejected the narrow submission that was being made.
Yeah.
So he starts in that paragraph with the wording of section 4, and then just pick up the bottom paragraph. Whether or not debts extends in section 1 to all provable debts, we find no grounds in the Act for construing the word debt in section 4 as referring only to debts in the pleading or procedural sense.
Sorry,
I'm so sorry.
I've lost
It is it's on 9 of the bundle, 275.
Yes.
So it's the bottom paragraph,
I
and this
see.
is important. So they say there are no grounds for construing the word debt in section 4 as referring only to debts in the pleading or procedural sense. And if your lordships could go up to the first paragraph, and it's 5 or 6 lines up from the bottom of that paragraph, he explains what is meant by the narrow procedural sense. And I want to just show you this in the second place. If the word debt is to be construed in its narrow procedural sense, so he identifies what that means as meaning a sum for which an action can be brought. So where in the bottom paragraph he says there are no grounds for construing the word debt as referring only to debts in the pleading or procedural sense, he means in the sense of a sum for which an action can be brought. And over the page, so it carries on. Considering the words in section 4 having regard to the use of the word debts in sections 30, 33, which is my Lord's point, and 1 subsection 1F, we would come to the conclusion that the council are a creditor and the unpaid rates a debt within section 4. So it's a debt, notwithstanding the fact that you can't bring an action on it. That is what they decide. And at the bottom of page 10, internal 10, 276, says, although in certain contexts the word debt means a liquidated sum which can be sued for, to treat the word as prima facie so restricted is, we think, to confuse, as Chief Justice Dallas said, the debt with the remedy. And that is significant. You mustn't confuse the existence of the debt with the availability of the remedy. And there is no requirement under the 1914 Act, and there's no requirement under 267 for it to be a judgment or a debt that you can sue upon. It just has to be a debt. While I am looking at the Bankruptcy Act of 1914, can I just take your lordships to the rear judgment debtor case, and that is in the authorities bundle at tab 8, which is page 67. And my learned friend has taken your lordships to this, but it's important that that your lordships should have a full grasp of this one. Section 6 of the Foreign Judgments, the 1933 Act provides no proceedings for recovery of sum payable on foreign judgment, and so on and so forth, and then held a bankruptcy notice based upon judgment of competent court in France cannot be set aside. First point to note, it concerns a bankruptcy notice, and if your lordships look at the third line down on page 67, where it says the bankruptcy notice was founded upon a judgment of a competent court in France for a sum amounting to something over £19,000.
And by bankruptcy notice, we're talking about the equivalent of, so we're talking about the document which served for the purposes of a
Act of
bankruptcy.
Exactly. Really significant an important point, because that bankruptcy notice is one of the only two places in the 1914 Act where a judgment was required.
So in a G case.
Exactly. And in order to understand the judgment of the Court of Appeal, one should look at a part of the judgment your lordships haven't seen.
Let's go, before going on, I mean, we've talked about Bishopsgate. This is another case where the submission seems quite optimistic when the judgment had in fact been registered. But anyway.
Well, your lordship will understand why when one looks at page 609. If I could take you, 609, it's 75. And what Sir Wilfrid Green said, I'm going to take you through the whole passage because this is important. I place upon the relevant language of the Act, it is only necessary to refer to Section 1 of the Bankruptcy Act, which is the Acts of Bankruptcy, as your lordships have seen, which provides for the service of bankruptcy notices.
Sorry, I'm struggling. Sorry.
Oh, I'm so sorry.
No, I'm just. Where are you reading from? Sorry.
I'm page 609, which is 75.
All the way through to 609.
All the way through. Because what's interesting is they get to the, if you call it the ratio, they get to that on the last page, and it's quite clear.
Yep.
And we'll look at the last page. I mean, just to be clear, that sentence begins, that being so, and that being the construction which I place upon the relevant language. So he is founding himself on the construction he's placed on the Act.
You'll see why.
Yep.
Yeah. So he says, I place upon the relevant, so he deals with 1914, and then he says it would perhaps have been more logical if I had referred to this, in other words, Section 1, at the beginning of the judgment rather than the end. It provides in 1G that a debtor commits an act of bankruptcy if a creditor has obtained a final judgment or final order against him for any amount and execution thereon not having been stayed, has served on him in England or by leave of the court elsewhere a bankruptcy notice under this act, and so on. He then says, it has not been suggested, and indeed could not be suggested, that those words, quotes, final judgment or final order, taken by themselves extend to anything save a judgment or order of a court within the jurisdiction. That is to say, in England, it would be a final judgment of the English court. And then he says that is the meaning of those words is, I think, beyond doubt. And that's why they have run into the problem of registrable judgments. Because as your lordship saw yesterday, the only thing the holder of a foreign judgment which is registrable can do is register it. And so he goes on to say, the effect of the Act of 1933, as I've construed it, is to place the foreign judgment, when registered, for the purposes of the bankruptcy notice, in the same position as if it was a final judgment of an English court. Therefore, the fact that those words in the Bankruptcy Act taken by themselves would exclude such judgment does not have the result of preventing a foreign judgment, when registered, from becoming the basis of a bankruptcy notice. So, the decision is, so your lordship see the problem. To present a bankruptcy notice under 1G, you had to have an English judgment, which meant that a foreign judgment made the subject of an English judgment could, of course, have been the subject basis of bankruptcy notice. However, if you fell within the 1933 Act, you couldn't get an English judgment, and in other words, because you couldn't sue on that, and that was the issue in re judgment debtor. The foreign judgment creditor with the registered judgment is placed in the position as if it was a final judgment of the English court.
So what I'm misunderstanding this. Somewhere in the intervening pages, he must have said that if you have an unregistered foreign judgment, you can't rely upon it for the purposes of serving a bankruptcy notice.
He didn't deal with the point, but that follows. It follows.
Yeah, okay,
absolutely.
That's what he's
for sure.
The last sentence seems to suggest.
Yeah, you don't have an English court judgment, and you don't have a judgment that is treated as if it is an English court judgment. And all of this is in the context of the bankruptcy notice. So what this decision does, it puts the 1933 registered creditor in the same position and able to serve a bankruptcy notice. And the ratio of the decision is that a creditor holding a registered foreign judgment can serve a bankruptcy notice under section 11G because they are treated as if it was a final judgment of the English court. It is not because a bankruptcy notice is execution. It is because section 11G required an English judgment. And registration put the foreign judgment holder in the same position as if it was an English judgment. And so the foreign judgment creditor would register their judgment under the 1933 Act if it was registrable, or, and this answers my Lord Justice Snowden's point, they would get an English judgment if it was not registrable, so they could serve a bankruptcy notice. Do not please lose sight of the fact this is all in the context of requiring a judgment for 11G in order to serve a bankruptcy notice. And it is for the Bankruptcy Notice Act of Bankruptcy. It has nothing at all to do with what is a debt in section 4, and it has nothing at all to do with what is a debt in 267. Now that the requirement for an act of bankruptcy has gone, and the requirement for an English judgment under 11G has gone, under the Insolvency Act 1986, for the purposes of a bankruptcy, there is no need to register a foreign judgment. There is no need to get an English judgment. And there is no anomaly under the 1986 Act between foreign judgments falling within the 1933 Act and those that do not. They can
Sorry, I wasn't concentrating properly on that last bit, so could you just say the last bit again?
Was it just the no?
The bit leading up to no anomaly. So just...
Well, now, I'll do both paragraphs. Both.
Yes.
I'm so sorry. Now that the requirement for an act of bankruptcy has gone, and the requirement for an English judgment under section 11G has gone, under the 1986 Act, for the purposes of bankruptcy, there is no need to register a foreign judgment. There is no need to get an English judgment. And there is no anomaly between foreign judgments falling within the 1933 Act and those which don't.
Yes, I see.
Because they can both petition on the foreign judgment debt. And that, to use the words, yes, that is the punchline.
Yes, I follow.
So the question is there a debt under the foreign judgment?
And I do entirely follow the way you put it. Are there bits in what Sir Wilfred Green says that don't suit you so well?
No, my lord.
I mean, for example, 604, where he says, of course, apart from statute, the only way of enforcing the judgment of a foreign court was by action.
He's talking about enforcement.
Yes, I see.
And one mustn't lose sight. And the reason why I showed you that last page, and the reason why I showed your lordships the Acts of Bankruptcy, and how this fitted together under the 1914 Act, is precisely because the only question they're considering is, well, you've got a registered foreign judgment. Can you serve an act of bankruptcy? In other words, can you put the foreign judgment holder in the same position as an English judgment creditor? That was the only question they were considering.
So, sorry, just picking up my Lord's point, though,
Yeah.
I mean, just at 604, 605, he's talking, sorry, I'm trying to pick this up in the middle of this big, long sort of paragraph. He's talking about an earlier statute of some sort, and 1868 Judgments Extension Act, which is within the UK by the look of it, But those, what he says is, of course, apart from statute, the only way of enforcing the judgment of a foreign court, so including Scots and Irish courts, was by action. The Act of 1868 did not take away from the holder of a foreign judgment his right to start proceedings to enforce the judgment, proceedings initiated by a judgment written the usual way. And if he'd taken such proceedings in the case, let me say, of a Scottish decreet, and had obtained judgment in them, there was nothing to prevent him commencing his bankruptcy proceedings on the basis of the judgment so obtained. He still seems to think that you need to, at least, is he suggesting that you still need to obtain an English judgment before you commence bankruptcy proceedings?
No, he can't be, because that's exactly what he doesn't say on page 609.
Well, no, he doesn't say, no, 609, I think he's, because at 609 what he's saying is that if you rely upon the 1933 Act, Section 6, that gave you an alternative way, if you like, of having the equivalent, as you put it a moment ago, of an English judgment.
Which is their language, as if.
Right.
Yeah.
But
Well, if your lordship...
But absent that, is he not still saying that you can't commence bankruptcy proceedings unless you have an English judgment?
Under 11G, you needed an English judgment or its equivalent. To serve a bankruptcy notice, you needed an English judgment or its equivalent. You don't need that anymore.
I'm just thinking around this, and possibly this is in a way that suits you. 606 at the top of the page, the Master of the Roll says, just as under the Act of 1868, so under the Act of 1920, bankruptcy proceedings were still open to the holder of a judgment covered by that Act if he chose to start proceedings upon the judgment, recover judgment here, and then issue his bankruptcy notice. Now, as I understand your case, you would say, well, the Master of the Rolls was focusing on G, and he wasn't excluding the possibility that someone with the foreign judgment could bring bankruptcy proceedings on a different basis.
No, absolutely right, my lord. If there had been, and this is the point that Justice Chadwick made in the Maxwell case, if there was another act of bankruptcy, then you can pursue the foreign judgment because that is the debt. You can still pursue the debt. You don't need a judgment, and this is important. You didn't need a judgment under the 1914 Act for anything other than the two acts of bankruptcy I've identified to your lordship, and you don't need judgments anymore. And we're going to come to it. These were all points Mr. Hunter was very alive to, and I'm going to come to that.
Sorry, before you leave this case, can I ask you about page 609?
Yes.
And the words that you really put at the heart of your submission, it's not been suggested, indeed could not be suggested, that the words final judgment or final order in section 11G extend to anything save a judgment or order of a court within the jurisdiction.
Yes.
I think I understood your argument, but why did Sir Wilfrid Green say that? Why was section 11G to be construed in that way?
Well, I think in order to, we need to go back. The language in 11G, which you get from 4 of the authorities, is if a creditor has obtained a final judgment or final order, and so on and so forth.
Yes, doesn't say anything in terms about an English
About
judgment.
it being English.
No,
But-
but he said, Sir Wilfrid Green says, it couldn't
That
be
means
suggested
English
that it extended to foreign judgments. Now, well, why? If not because the conflicts rule says we don't treat foreign judgments as creating a debt.
No, that doesn't follow because you're...
But what other reason might there be?
No, it's just because of the use of judgment. He is construing that. It's not to do with debt. It's to do with judgment.
Yes, but
And-
why does he limit it to English judgment?
Could not be suggested that a final judgment or final order can extend to anything other than an order within this jurisdiction.
Yeah, why not?
Because this is bankruptcy was an act of bankruptcy. This is pretty national. But the point doesn't matter.
Well, is it not because
No, no.
of the overarching conflicts principle
I don't
that
think
judgments
they
are
have that in mind.
territorial?
A judgment is territorial.
It's
for the
territorial.
purposes
It's
of
an
act
exercise of
bankruptcy.
sovereignty, and for the purposes of bankruptcy legislation.
Yeah, but he's
Put
not.
it broadly, I quite understand you say he's not examining what's meant by
No, no,
debt, but I just wonder what you say the reasoning is behind this statement.
Well,
What
I can
possible
only
reason
look at
could
the
there be?
statement. But what I would say is your lordship's right. It's territorial in the sense of judgments. But if your lordship were to try and extend that to debt, that would be wrong, because this only goes to acts of bankruptcy, and there is nothing
That I understand. I entirely understand
No,
that.
exactly. Which means, so he's not saying, I am reaching this conclusion because of the conflicts rules that therefore mean there is no debt. In other words, the judgment, foreign judgment, is impeachable, therefore there's no debt. He's not saying that.
No, because he's not focusing on debt, but he is saying
But he's saying
this statute requires an act of bankruptcy. It
Yes.
says in terms a final judgment or final order. It couldn't be suggested that could mean a foreign judgment. And what I imagine is said against you is that's because a foreign judgment is not treated by the English court as having any effect.
well, no, that's going too far.
But I'm asking you, what alternative reason do you suggest there might have been?
I'd suggest that what he was looking at is something that causes a debtor. If one looks at section 1 and goes through it, it is acts that occur in England. So it is very national in its approach, and the debtor has to.
Forgive me, I've lost section 1.
I'm so sorry.
Where is it?
It's in the authorities bundle, tab 1.
The main authority.
The main authorities bundle.
Thank you. I'd forgotten that.
I think it's worth, for this purpose, for your lordship to look at section 1 and also subsection 2, which I haven't looked at. First of all, if your lordship looks at subsection 2, so a debtor has to be personally present in England, has to ordinarily reside in England, carrying on business in England, member of the firm partnership in England, and also, if your lordship goes back to 1, the act of bankruptcy, if in England or elsewhere, England or elsewhere, and obviously there's going abroad and not coming back. And then it says, if a creditor has obtained a final judgment or final order against him for an amount, an execution thereon not instated, served on him in England or by leave of the court elsewhere, a bankruptcy notice doesn't within 7 days. It's Anglo-centric, and rightly or wrongly, what Sir Wilfrid Green has said is he said no one can suggest this means anything other than English judgment.
I'm not sure quite why you're making that submission, or at least I'm not sure where it's going. As I understood it,
Yeah.
Standing back a little bit, the general concept of English insolvency, corporate and personal, is that when it comes to, at least to the distribution phase, and indeed to the collecting in phase, the insolvency is sort of worldwide, at least it nationally has worldwide effect. In other words, subject to not trampling over the toes of foreign jurisdictions. It's the job of an English liquidator to get in assets of the company worldwide, and we don't ring fence the procedure for English creditors. We allow anybody from the rest of the world to come in and prove,
Yeah.
subject to certain overlays. example, foreign revenue laws,
Yeah.
as being an obvious one. So when you point out that the Act of Bankruptcy was very Anglo-centric, that might be thought to emphasise that at least under the 1914 Act, although we were very universal in allowing people to participate in the process once it was underway, the actual initiation of the process was very much domestic and focused on whether you had in England you could satisfy certain criteria. Why wouldn't that support the proposition that if you were relying upon a judgment, you could only do so if it were a foreign judgment, if you had either registered it or could fit within Section 6 of the 33 Act?
Well, that's what Sir Wilfrid Green is saying.
And I think the point, but so he's only so he is effectively acknowledging the common law proposition that if you just have a foreign judgment, nobody could suggest that you were entitled to initiate bankruptcy proceedings without more.
No, I think, my lord, that is reading way too much into.
But I think that's the point that's being put to you, unless I've misunderstood.
Okay, well, my answer to it is reading way too
Sorry,
much.
I may have misunderstood the point, but I think that's the point that was being put.
Yes, but I quite understand the distinction you're drawing between the 1914 Legislation Act of Bankruptcy and where we are now under the 1986 Act. I entirely understand that, and I entirely understand your argument that Sir Wilfrid Green's reasoning was, you say, you start with 11G, that only applies to English judgments, and therefore all the case tells you is that under a scheme which has gone, you couldn't treat a unregistered foreign judgment as coming within 11G as an act of bankruptcy. But I quite understand all that, and I was on the point was why has he confined 11G to English judgments when it doesn't say so? And your answer to that was, well, the other aspects of acts of bankruptcy are English centred. I think have I understood your answer?
That may not be a good answer. I mean, your lordship's asking me, was Sir Wilfrid Green reading something bigger than it has to be an English judgment? You've got a judgment. What we've got is we've got a judgment of the Court of Appeal that says it wasn't suggested, so it wasn't debated, nor could it be. I think that was indeed could not be suggested that it's anything other than an English judgment. Now, that I would respectfully suggest does not bring with it a detailed consideration of all of the other aspects that your lordship is raising. He took it as meaning an English judgment, and he then said the answer is, and this is as far as the case goes, the answer is if you register it, you're treated as if it's an English judgment. And so the holder of a foreign judgment has got two possibilities. You either register it, in which, and this is under the 14 Act, you either register it, in which event you're treated as if, for the purposes of bankruptcy notice, or you get an English judgment, in which case you've got an English judgment.
Can I come back to that and the anomaly question?
Yes, I can't see that there is one, my lord.
Well, can we go to the bottom of 607, where the Master of the Roll says, whereas the earlier legislation still left it open to the judgment creditor under a possible penalty, it is true, as to cost to sue in the old way on a Scottish, Irish or Dominion judgment. Under the present Act, Section 6 prohibits any such method of dealing with a foreign judgment if it is a judgment registrable under the Act. So in other words, Section 6 means you can't do anything other than register.
I think I said that earlier, and that's why...
Yeah, well, can I go on a
Okay.
bit? In other words, where the judgment is registered under the Act, the only thing that the holder of such a judgment is entitled to do is register it, and after registering it, of course, he obtains the rights which the Act expressly says. And that's based on Section 6. Section 6 says no proceedings for the recovery of a sum under a foreign judgment, being one to which the Act applies, other than proceedings by way of registration, shall be entertained. So the hypothesis has to be that Section 6 means you cannot resort to the old method of
getting a judgment.
and then enforcing that way. And surely means you can't present a bankruptcy petition except by getting registration and then going this way. And if that's right, the anomaly remains because you still can't enforce a foreign registrable judgment except by getting registration, regardless of the fact you don't need a judgment anymore.
Yeah, no, with respect, no. It only goes to whether or not you've got something that is the equivalent of a treat as if it's an English judgment, and you would need an English judgment in order to serve a bankruptcy notice. It goes no further than the bankruptcy notices, and it does not apply to the debt, and bankruptcy is not enforcement.
Why would Section 6 be important at all if it weren't being assumed that a bankruptcy petition was proceedings for the recovery of a sum payable under a foreign judgment?
Because you needed a judgment for the purposes of 11G.
But you did for 11G, but here we get no proceedings for the recovery of a sum payable under a foreign judgment.
Yeah.
Well, the hypothesis is that the bankruptcy petition is proceedings for the recovery of a sum payable under a foreign judgment.
Yeah, no, this wasn't about a bankruptcy petition. It was only a bankruptcy notice.
But
this isn't a
the
bankruptcy
reason why you
petition
can't
case.
petition,
No,
why you...
No, I'm sorry, my lord, but this is important. It is a bankruptcy notice case. This is not a case in which someone had brought a bankruptcy petition and had been told they can't do that. And there is no such case. This is only, and it's one of the reasons why I wanted to point out those differences. It's only about bankruptcy notices. Really important that we limit ourselves when one gets to the role of judgments in an insolvency. We limit ourselves to why it was required back under 1914, and we don't then confuse the position when we move forward to consider, is there a debt? It's a different question. And as Mr. Justice Chadwick points out in Maxwell, he said if there'd been a different act of bankruptcy, it's a debt, and you could have petitioned on the debt.
And I see that subject to Section 6, and there is... I mean, I'll have to read this very carefully and think about it. But if Section 6 means that when you've got a registrable judgment, you have to register it if you want to bring bankruptcy proceedings, regardless of...
Absolutely not.
Section, the old G...
No.
Then you've got the anomaly argument.
No, absolutely not, my lord, because this is not proceedings for the recovery of a sum payable under a foreign judgment. You don't get to that point. This isn't.
I understand you say that that's what the issue in the case was, but there is a whole section at 608 about what Section 6 does and doesn't do.
Yeah.
Now, you say that was entirely irrelevant to the question they had to decide.
It certainly wasn't. No, absolutely. The decision is on.
I understand that. Entirely irrelevant to the decision they had to decide. And yet it was said. So treat it for the moment as though it's not part of the ratio, but simply part of the reasoning on the way, or even, you might say, an irrelevant dictum. But what is said about Section 6, even if it wasn't necessary for the case, is it would prevent you bringing bankruptcy proceedings on an unregistered foreign judgment because Section 6 would prevent you doing so.
Yeah,
he cannot sue on it. Section 6 prevents him doing so.
But my lord, you cannot.
And you say that's wrong.
No, I don't say it's wrong at all. It's because the context in which they were considering whether or not you could bring proceedings, the context is 11G. It is because they are considering a bankruptcy notice under 11G which requires a judgment. That is the point. And those are the proceedings. Those are the proceedings and nothing else. This is not a bankruptcy petition, and for that you just need a debt. I showed your lordship Section 4, I showed you, and your lordships have 267. It's just a debt. And it is reading, if I may respectfully put it this way, it's reading, putting far too much into the 1933 Act and Section 6 to take from a consideration of whether or not a registered foreign judgment is capable of supporting a bankruptcy notice served under 11G and then say, right, from that, I can read that you can't take any other bankruptcy proceedings. With respect, it doesn't do that. I'm sorry. And as I said, you go back to Maxwell, where Mr. Justice Chadwick pointed out very, very clearly that they are two distinct things and they don't have to correlate and so on. You needed an act of bankruptcy and you needed a debt.
I mean, just going on, but if the argument for the respondent were correct, it would produce this startling result, that it would not be open for the holder of a foreign judgment registrable under the Act ever to enforce that judgment in bankruptcy, because he can't sue on it. And Master of the Rolls says, no, well, that's not right, because once you've got registration, you've got the equivalent of an English judgment.
Yeah.
But he's not disputing the idea that if that weren't the case, it would not be possible to bring bankruptcy proceedings.
Because of 11G. Because you
But you say, well,
No.
that 111G was never the only way in which this could arise.
No, that's absolutely right, my lord. But when you are a judgment creditor, when you're any sort of creditor, judgment creditor, the first thing you need is an act of bankruptcy. You can't assume there's going to be another act of bankruptcy. There's got to be an act of bankruptcy. It's got to take place within 3 months. So if you're the creditor and you're, in those days, a judgment creditor, the first thing you do is you serve your bankruptcy notice. And then you serve a petition which is based on your debt. Now, you can't, it's possible that the debtor may have kept house or taken one of the other steps. Of course it's possible. And you may sit there and you may think to yourself, I'm going to wait for an act of bankruptcy and then I'm going to present my petition. But that wasn't the question in the case. And I would respectfully submit that Sir Wilfrid Green, in this case, is not intending to go beyond what they were considering, which was, could a registered foreign judgment found a bankruptcy notice? And that is where I would respectfully draw the line.
Thank you. I have your point. I'm sorry to have slowed
No.
so much.
I'm sorry. I'm grateful that your lordships have got the point. So I move on then to, is there a debt under the foreign judgment? And in our respectful submission, the only question is whether Mr. Drelle owes Servis-Terminal a debt that satisfies the conditions of 267. It is incontrovertible that Mr. Drelle is subject to a final judgment debt in Russia for 2 billion rubles. The debt arose on the judgment. Can I then take you to Dicey Rule 51, which is the starting point, which your lordships will find in tab 42 of the authorities. Dicey is all in tab 42 and 51 is at 808. And what 51 makes crystal clear is that the idea that a foreign judgment debt does nothing in this country is completely wrong. So Rule 51 provides a foreign judgment which is final and conclusive. Foreign judgment which is final and conclusive, which we have got. On the merits, which we have got. And not impeachable under any of the rules 52 to 55, is conclusive as to any matter thereby adjudicated upon, and cannot be impeached for any error of fact or law. And if I can, I'm going to make some submissions on this one. I've shown you a couple of passages. If you could go forward then to page 810, which is 14.120, where it is explained that in Carl Zeiss, a majority of the House of Lords held that issue estoppel can be based on a foreign judgment. And this decision was applied by the House of Lords in Senna. 3 conditions must be fulfilled before issue estoppel applies. The judgment of the foreign court must be of a court of competent jurisdiction, which it was, and must be final and conclusive on the merits, which it was. in the sense of Rule 46. There must be identity of parties. There must be identity of subject matter. That is to say, the issues must be the same. In the Colzai set, it was not expressly laid down foreign judgment must not be impeachable on any of the grounds referred to in Rule 51, i.e. 52 to 55, but in the Senate it was made clear that the foreign court must be competent in the sense of it having jurisdiction in the international sense over the parties to be bound, and it can hardly be supposed an estoppel could be based on a foreign judgment which had been obtained by fraud. Closely parallel to the rule that a foreign judgment is conclusive is the rule that the defendant must take all available defences, but we're not concerned with that. So the Russian judgment is conclusive as to the sum owed by Mr. Drelle to Servis-Terminal. The question whether Mr. Drelle is liable to Servis-Terminal has been determined. It has been determined that there is a debt of 2 billion rubles, and that...
But that's just assuming, hang on, that there is a judgment of a Russian court ordering him to pay a sum of money.
No, it's actually... It's why I showed you the issue estoppel point. It is determinative of, conclusive, as to any matter thereby adjudicated upon. And you can't criticise it by way of fact or law. And it gives rise to an issue estoppel. And that's important, if I may respectfully submit.
Yeah, I'm just picking up the use of the word debt.
Oh, I'm sorry. I didn't
Sorry.
follow the logic.
There is a Russian judgment which is final and conclusive on the merits.
Yes.
The merits were whatever the underlying claim was. It wasn't a claim under contract. It was a claim
it's breach of duty,
misappropriation of assets.
Duty case.
So I was only picking you up because you were saying that it gave rise. It was final and conclusive that there was a debt.
Well, it's a judgment debt.
Well, as the Russian courts would interpret.
Yes.
Whatever the Russian courts ordered him to do, he was required to do it. The question of whether it's a debt for the purposes of the Section 267 is not determined by the Russian court.
No.
I don't think you're saying.
I wasn't trying to say that.
Right. That's what I was just trying to tease
But the
out.
point-
What I was trying to tease out is whether you were saying that a determination by the Russian court
That there is a debt.
that there is a, quote, debt was determinative
So-
for the purpose
so
of
breaking it-
267.
Breaking it down, the determinations that he acted in breach of fiduciary duty and that as a consequence of those breaches of fiduciary duty, he is liable to pay this sum of money to the company, that is all determined. And those are facts that have been determined.
He is liable in damages. That's the adjudication.
Yes.
The consequence is
But
a court order ordering him to pay that sum.
Yeah, we'll have a look at it. We'll have a look at it.
But is that the right analysis? The adjudication is on a claim in damages and holds that there is an obligation to pay damages in a particular amount.
Yes, and we
And
say
that
that's a debt.
then the consequence is the court makes an order, which is that amount should be paid, and it's the order, in English terms, which gives rise to the debt. Is that the right way of looking at it?
Well, I'm not sure whether my lord is trying to salami slice the debt off. the debt is consequential on the judgment.
Yes.
And you can't... It would be a little bit like, going back to the case we were looking at earlier, it would be a little bit like distinguishing between the remedy and the underlying right.
Well, let me put it in this way: under issue estoppel,
Yeah.
would the Russian judgment give rise to an issue estoppel as to whether Mr. Drelle's liability that was being considered by the Russian court was itself a liability in debt or a liability in damages? I suggest it would only be an issue estoppel as to whether, before the judgment was given, he owed a liability in damages.
He owes a liability under the Russian legal system, which the claim, he owes a liability to pay 2 billion rubles because he acted in breach of his fiduciary duty in, as your lordships have probably picked up by now, lending out 2 billion rubles to someone who was never going to be able
Yes,
to.
but from an issue estoppel point of view, suppose that there arose an issue in England about whether there was what we would call a debt or what we would call a liability in damages for the conduct in that Mr. Drelle had undertaken. It would not create an issue estoppel in this country that what he had done gave rise to a debt, would it?
Well, yes, because the liability to pay damages is a debt.
Well, no, because
because
that's
liability to pay damages is not a debt, and it's not a debt under the bankruptcy legislation.
I mean, the Russian, if the third requirement of an issue estoppel, as just identified in that particular paragraph, is that there should be an identity of the issues. The issue before the Russian court wasn't, does Mr. Drelle owe a debt? The issue before the Russian court is he liable for breach of fiduciary duty to pay damages?
Yes. And a judgment that holds you are liable to pay 2 billion rubles by way of damages falls within the definition of debt within 267.
Right, but nothing the Russian court...
The Russian court isn't determining it's a debt.
Correct.
But the consequence is it's a debt.
It's not adjudicating on whether
it's not
adjudicating on whether it's a debt, but the consequence of its adjudication is to create the debt. Is that a fair way of putting it?
Yes, and I think that's right. It's the consequence of the adjudication that he is liable in damages. Creates a debt because when one looks at the definition of debt for the purposes of 267, it would include that.
Right, that's your submission, yeah.
Yeah.
I think we're all just...
Okay,
I've struggled slightly because you took us to an issue estoppel bit, and we were sort of trying to worry. I was certainly trying to worry whether you were actually asserting that there's an issue estoppel arising out of the Russian judgment preventing Mr. Drelle from saying this isn't a debt within the meaning of Section 267.
No, I'm not trying to
And I
say
think
that. But that's the consequence.
was also struggling
but what
with
he
that as
can't
well.
do is he can't, unless it's impeachable, which we'll come on to, what he can't do is he can't say, I am not liable in damages under the relevant Russian provisions, which we're going to look at a bit briefly.
I must admit, I don't think I've ever actually looked at the Russian judgment.
My lord, I am going to take your lordships to the Russian judgments.
So somebody's done this homework better than me.
Yeah,
But the debate we've been having is important because it rather frames whether Rule 51 of Dicey is the right starting point. Because Rule 51 of Dicey is looking at what is conclusive by reference to matters that are adjudicated upon.
yes.
And I think that the formulation that I put to you and you accepted was that the Russian court did not adjudicate upon whether there was a debt.
No, the Russian court adjudicated that there was a liability
Yeah.
under the Russian system, and that gives rise to a debt as a matter of English law under 267. So however one wants to skin it, one gets back to there being a debt. And what your lordships know is that that was confirmed on appeal, which was a full review. It was considered by the Court of Cassation and a petition to the Supreme Court was dismissed. It is unappealable in Russia. As to whether that gives rise, this is my very next point, as to whether that gives rise to a debt in England, the answer is yes, because it gives rise to a liability to pay that amount of money to Servis-Terminal unless that judgment is impeachable under the Dicey rules, and that is the only basis for there to be a dispute between Servis-Terminal and Mr. Drelle. On a bankruptcy petition, the question is whether there is a bona fide dispute on substantial grounds that the judgment can be impeached. And can I just show your lordships, if we go to the judgment, Mr. Justice Richards, paragraph 43, so at A91, So he says, in my judgment, Rule 51 is significant. For purposes of ground one, I assume the judgment's not impeachable. On that basis, the effect of Rule 51 is that when considering whether the judgment gives rise to a debt for the purpose of 267, it's taken to be conclusive that any matter it adjudicates. So accordingly, and this is how it works, for the purposes of 267, it is to be assumed conclusively Mr. Drelle presently owes 2 billion rubles as determined by the judgment. And that is conclusive of that.
Well, I'm just not sure I accept the logic of these two sentences. He says that's a strong indicator that he owes a debt. And I assume because he's put the word debt in inverted commas, he means a debt
Yes.
as defined by Section 267.
Yes. And that is because...
But, I mean, he's made a in the sentence beginning accordingly, he's made a leap of logic, hasn't he? Because it can be assumed conclusively that Mr. Drelle is liable in damages, if that's what the Russian court has ordered or has determined, and has ordered the payment of a sum. That's what you must assume conclusively that has happened. Can't be challenged here. But whether he owes a
Presently
debt.
Forget the word debt for a moment. He presently owes. He has a liability.
Well, owes is. What do you mean by owes?
He has a liability to pay 2
Right,
billion
okay.
rubles to ST. There is no way of getting around that.
That I think is fine. But why does it then track logically? Or why does it strongly indicate that he owes a debt within the meaning of 267? I mean, I'm just not sure it logically follows.
Debt is so widely defined.
Yeah, but I don't see why you get any support from the mere fact that the Russian court has made a determination in the judgment. I mean,
Where's it gone?
anyway, it perhaps semantics. I mean,
Yeah, I think, with respect, my lord, you're moving away from the substance. Sorry, I'm just trying to dig up. You know, let's not lose sight of 382 references to a debt or liability. Present, future, certain, contingent, amount fixed or liquidated. It is a sum of money he has been ordered to pay by the Russian court to Servis-Terminal.
Does it follow from your argument on this that would equally be the case if there were a judgment against him by a court of some self-professed group in some country which we didn't recognise?
Well, if we didn't,
It would still be a foreign judgment, and
No.
on the assumption, which you say has to be made,
Yes,
or that,
the
that
answer
it's
is
not that it's not impeachable, it is still something that is recognised as giving rise to a debt.
Adams and Cape. No, it isn't. Because there's no jurisdiction. Your Lordship has hypothesised the question of whether or not there's jurisdiction. The question of whether it's a competent court is a question of English law, and that is Adams and Cape.
Well, that's whether it's impeachable. That's
No.
not whether there's a
No,
debt.
I'm
is
sorry,
it?
my lord. On jurisdiction, Adams and Cape it deals with that point. And what the Court of Appeal decided in Adams and Cape, and it so happens that I've been representing Cape in what you might call Adams and Cape too. So I was arguing about this in front of Miss Justice Mann only a couple of weeks ago. But in Adams and Cape, the Court of Appeal held that the question of whether a foreign court is a competent court for the purposes of giving a judgment against an individual is an English law question. So by postulating the question the way your Lordship has, you're suggesting that it could be anybody, if I'm putting it slightly tendentiously, but I think this is what your Lordship was saying. Anybody decides they're going to take jurisdiction and they're going to grant a judgment, and therefore I'm saying it's only if it's impeachable. It's got to be a competent court, and there is absolutely no suggestion that the Russian court was not a competent court to have jurisdiction over Mr. Drelle, and therefore Rule 51 kicks in.
I mean, an oddity about the judgment is the judge has hived off entirely Rule 45.
Rule 45 doesn't.
Rule 45 says a judgment of a foreign court has no direct operation in England.
Yes, we're not talking about direct operation in England. We're not talking about enforcement or direct operation or any of the above. We're talking about whether it gives rise to a debt. And that is fundamentally different. And that's, we're not here, we're not here dealing with enforcement or direct action on the judgment. We're asking ourselves, is there a debt? And Rule 51 says that that judgment is, to put it loosely, is binding insofar as it deals with any of the issues, unless it's impeachable. And this isn't enforcement. So the only question that you have to ask, and we're going to look at some of the Russian cases, at least I hope. I'm getting worried about the time, I've got to tell you. But these judgments give rise to financial liabilities, which we say fall within the definition of debt, and there is absolutely no reason why petitioning for bankruptcy is not one of the steps that you can choose to take. So,
Can you take any other?
I'm sorry?
Can you take any other
What, without
recognition?
I haven't thought about that.
I mean, you say it's one of the steps you can take. Well, you
Yes.
can't bring proceedings, you can't distrain, you can't enforce.
Well, no, but you could either sue and get an English judgment on it, in which event the question is it impeachable? And this is like any other debt, in the sense that you have to ask yourself, is there a bona fide dispute? And if there's a bona fide dispute, then of course you have to go off and you have to deal with it in proceedings. But if there's not a bona fide dispute, you are entitled to petition and obtain a bankruptcy order, which is what we've done. So now, what I wanted to do is I want to look at the three cases that consider bankruptcy on a foreign judgment, and then I want to turn to the textbooks. Before going to grounds for impeachment, I'm sorry, this is taking a lot longer than
No, well, you've had a lot of questions.
But anyway, let's go to PACE Europe, which is Authorities 22. And this is
try not to interrupt you, Mr. Phillips.
Oh, no, that's the whole point, my lord.
Well, we're trying to minimise our interruptions.
No, the temptation to speak quickly is one of my biggest weaknesses, and I must avoid it. So PACE Europe, which is in tab 22, which is 361 in the authorities, and it's a decision of Judge Pearl sitting as a High Court judge. It's an application to set aside statutory demands in respect of sums claimed due under a judgment of a court in North Carolina. Your lordships will see that from the head note, the judgment consisted of various component elements. Compensation was assessed at $2.1 million US. There was a set-off. The total amount of the award, so there's an award, $5.382 million US. Mr. and Mrs. D sought to set aside the demand on the basis under Section 5, an award of multiple damages couldn't be registered. Judge Pearl said, and I was going to pick up the third point, was the court did not sit as a court of appeal in respect of North Carolina jurisdiction, and the case management decisions of the North Carolina court in refusing an adjournment for the period were rational. If I could ask your lordships just to cast your eyes over 22 to 26, which explains the problems. There was an application for an adjournment on the grounds of a heart condition and so on. And it was they didn't attend the court, and the hearing went ahead, and in 31 they decided there was no good reason for the failure, and then really 33. In any event, this court does not sit a court of appeal in North Carolina court. The court came to a rational case management decision. The inevitable consequence was that the trial proceeded as the Dunhams must have realised there was a real risk in their absence. The result was a substantial judgment against them. 34. Given that the adjournment was justifiably reformed, seems to be impossible to characterise as a denial of natural justice. The Dunham's argument, expressed skillfully by Mr. Elias, not Lord Justice, is that the North Carolina court simply did not allow the Dunhams sufficient time in denying their motion for continuance of the trial itself. Said inferentially, the motion for continuance should have been heard in advance of the trial. That, of course, is the sort of thing that happens in an ideal world, but the Dunhams knew that had not happened because they'd not been notified of an adjournment of the trial. No basis for assuming, unless and until they were told otherwise, the trial which was on would in fact be off. They deliberately took the lead of trial's proceedings in their absence, and they are now reaping the consequence. Those circumstances seem to me district judge, I expect his industry in producing very short notice careful which are plainly wrong, finding that there was anything arguably amounting to a denial of natural justice. And so the statutory demand stood. And this is a question, this is an unregistered foreign judgment. The question of impeachability was raised, proceeded in the bankruptcy court. It was good for a statutory demand and petition. Moskalev, which is...
The point we're now grappling with wasn't really being taken, was it?
No, my lords, your lordships are the only ones who spotted that point, and put it that way. But I mean, I'm not quite sure what your lordship's getting at. I'm not going to show your lordships authorities that answer every single point in the case. So what I've got here is an unregistered judgment. Judge Pearl decided that it wasn't impeachable, and that therefore the statutory, the bankruptcy notice could continue.
And it was assumed without any argument or addressing the point that an unregistered foreign judgment was sufficient to justify a statutory demand.
Yes.
That's what you get out of it.
Well, that's what I get out of it, absolutely. And now, if you look at Moskalev, which is in tab 33, which is a decision of ICC Judge Barber. Again, this is an application to set aside a statutory demand. The statutory demand had been withdrawn, and it left the question of costs. What it was in paragraph 4, is a default judgment.
Sorry, which tab are you in? Sorry.
Oh, I'm so sorry. 33?
33.
Yeah.
Thank you. Sorry.
So it's a default judgment from the High Court in Hong Kong. Paragraph, go forward to 26. The applicant's fallback position is that even if the applicant is not treated as a successful party, the respondent's conduct before and during these proceedings warrants an order for costs against him. In this regard, the applicant's summary lies in the respondent's failure to take the proper steps required to have the Hong Kong judgment recognised in England well prior to service of stat demand. So, the point that was taken on costs was they should have had the judgment, Hong Kong judgment, recognised before service of the statutory demand. And in paragraph 27, in my judgment, this of itself would not warrant an order for costs against the respondent. It is well established that service of a statutory demand does not constitute enforcement. For such purposes, it follows the respondent did not have to take steps to render the judgment enforceable prior to service of a statutory demand. So, I would respectfully submit that the fact is statutory demand in this case rather than a petition does not assist my learned friend, because 267 is based on debts, statutory demand is based on debts. The word debt follows right through.
I mean, I follow that, but that's not what the Judge Barber was saying.
No, Judge Barber was saying you don't have to register it, you don't have to, it doesn't constitute enforcement. The question you are dealing with under a statutory demand is whether or not there's a debt. And that's the question. And the debt language runs right through 268 back to 267. That is the only trigger language.
I mean, if she's right with her third sentence, that you don't have to take steps to render a judgment enforceable prior to service of a statutory demand, and if a statutory demand requires there to be a debt in the same way as a petition, then I can see that supports your argument.
Well, it does, and that's why I'm citing it. Thank you.
Get that? What's the authority for it?
What, that it's not enforceable? Well, it's a combination. It's actually all of these cases.
She says it's well established. I mean, that suggests that it's so obvious it goes without saying, and everybody down there, everybody in the ICC corridor knows it.
Yeah, no, absolutely, and I'm going to come back to that when we come on to who wrote Muir Hunter.
I mean, the difficulty here is that sentence. She's talking about whether or not a statutory demand is enforcement. That's not your point.
No, that's right, but it has to be a debt. So,
but that is your point.
No,
but that's not the basis on which she decides this.
Absolutely, but the point about getting a judgment or registering is if you want to enforce it, then you do go down that route. And the point that is made in the bankruptcy cases is you don't have to do that because all you need is a debt. You do not need an enforceable judgment, and that is the significance. And it's a debt, and it's a debt for the purposes of statutory demand. It's a debt for the purposes of petition.
And this case would help you if Judge Barber had said it's well established that a foreign judgment is a debt, therefore there's no problem. But she didn't say that.
Well, let me continue. I'm giving you little bits of the jigsaw. I'm not going to ask you to read things into judgments. I've already resisted that in relation to the earlier judgment. So the next one is Sun Legend, which is Authorities 24.
Sorry, which tab?
24, my
Thank
lord.
you.
So this is another judgment debt from Hong Kong. Sun Legend presented a bankruptcy petition. H, if you look at the second paragraph, H opposed the petition on the basis no English judgment had been sought in respect of the Hong Kong debt held. This was not a situation where the creditors were seeking to enforce a Hong Kong judgment debt. Rather, it was a case where an admitted debt, and you know this one was admitted, which was also evidenced by a Hong Kong judgment, was subject to bankruptcy petition under English law. There are no policy reasons for refusing to recognise a Hong Kong judgment. No requirement under the Insolvency Act that bankruptcy petition founded on an undisputed debt should be based upon a judgment of the English court. And then I just want to show you paragraph 6, which deals with the ground for opposing, failed to obtain an English judgment for the Hong Kong debt. And then it points out that the only mechanism is to bring an action on the Hong Kong judgment, seek an English judgment based on it. And paragraph 7, Mr. Najib contends the petition is an abusive process because no English judgment has been obtained. And then going all the way forward to 28, I agree with Mr. Weaver's basic submission that Sun Legend has a cause of action and is in a position no different from any other creditor who seeks to pursue bankruptcy without holding an English judgment. Mrs. Ho is perfectly entitled to oppose the petition on substantive grounds. She has chosen not to do so, nor did she apply to set aside the statutory demand. If she had any point in relation to recognition, there is no reason why it should not have been raised. So a point that is being noted there, and it's District Judge Musgrove. The point there is that points in relation to recognition of the Hong Kong judgment could have been raised. I also accept the submission the bankruptcy petition does not constitute enforcement of the Hong Kong judgment. Same point again. Bankruptcy jurisdiction since 86, separate jurisdiction involving class remedy. Your lordships have that point. No requirement of an English judgment as a precondition to proceeding with a petition. There is, in my view, a debt due to Sun Legend, which satisfies the requirements of the Insolvency Act, and then the conclusion in 30. So it proceeds.
There's a whole series of propositions there. She says, I accept the submission that a bankruptcy petition does not constitute enforcement of the Hong Kong judgment. The bankruptcy jurisdiction is a separate jurisdiction involving a class remedy.
Mm-hmm.
Is the second of those sentences actually support for the first?
It can be, my lord, yes.
I mean,
it is, as your lordship knows, this is a very different, if we can put it this way, animal.
well, it's a process of collective enforcement is the way it's normally put,
Yeah.
not a class. I mean, it is a class remedy, but it's a
Yes.
class remedy by way of collective enforcement.
Yeah, but it's not
Or
individual enforcement. In other words, you're not enforcing your debt. You are invoking a collective remedy for the enforcement, for the dealing with the estate. And as Lord Hoffman said, and your lordship is absolutely right to pick that up, it is a form of collective enforcement of the debts. That is not an individual enforcing a judgment. So, and I don't need to go through the examples of what all the other forms of enforcement are.
Well, a bankruptcy process is enforcement collectively of on behalf of people who hold provable debts,
Yes,
which include the person holding a judgment,
yes,
you say.
yes.
And therefore, why isn't it, at least in part, enforcement of that person's judgment, together with all everybody else?
Well, because you don't need a judgment in order to get the bankruptcy. You get back to the fact that all you need is a debt. And that really is, as I said, this case is very simple. It really is where it comes about. Now, if it's a form of enforcement which requires a judgment, that's what I would respectfully submit District Judge Musgrave is getting at. It doesn't. And I've shown you that the old requirements for judgments in the Bankruptcy Act, and you don't have that anymore. There is no requirement for a judgment. You are not enforcing a judgment. You are petitioning on a debt. And so I either satisfy you that the Russian judgments give rise to a liability which is a debt within 267 or not. And that's what this is about. Now, ICC Judge Burton and Mr. Justice Richards, in my submission, absolutely rightly have said that does give rise to a liability as a result of this judgment, unless that judgment can be impeached. And that's the question that they then ask. And you ask, is there a bona fide dispute that that judgment can be impeached? And that's the question that they look at.
So, I know in a sense I'm just restating the question, but I think it's accepted that if you wanted to use the processes of this country to enforce a judgment of a foreign court for the benefit of the judgment creditor alone,
Yes,
you need to register it.
yes. Or get an English judgment on an action.
Yes, you need to have one of those two to be able to use our processes,
Yes, that's right.
our jurisdictional processes.
Yeah.
You say, however, you can invoke our processes of collective enforcement, bankruptcy, without doing so.
If you've got a debt.
Yes.
If you're accredited.
I know you
with a
said it
debt,
all turns on the
Well,
question of debt.
no, I know, but-
What's the logic for that?
it's a completely different. It's a completely different thing.
Well, I know it's a different thing, but that's
It's a
not really
completely
answering.
different
That's
thing.
not really answering the logic. Why?
Well,
Why?
That I think is the logic. Oh, sorry, I shouldn't say that. Sorry.
What? Why? I am slightly puzzled as to what the sort of policy underpinning for a result, which is that this country requires you to take steps to register your foreign judgment before you can do anything individually by way of enforcement of it. But you can skip that step if you are seeking to invoke this country's collective bankruptcy or insolvency procedures. What's so special about bankruptcy or insolvency in terms of our process? I know they're different.
Yeah, no, but what's so special is the difference. You see, what you've got in relation to individual enforcement is you have got a creditor coming along and, for example, attaching an asset and taking the asset for themselves. And they're doing that based upon the foreign court judgment. And that is different to coming along to the court and saying, because of this judgment, I am a creditor of this individual and I would like to start a process which is for everybody. That is qualitatively very different.
Well, of course, I understand that being a sort of
Well, I know.
dyed-in-the-wool insolvency law. I think I do understand the difference between individual execution and collective process. But it's not really that perspective I'm trying to get you to focus on. From the perspective of this country's justice system, i.e. using a process of these courts, where we have jurisdiction within this country, if you try and bring your foreign judgment and do one particular thing, you are told you can't do it until you've either got an English judgment or you've registered your foreign judgment. You can't use our justice system, our process, in that circumstance. But in the other circumstance, if you're right, we say, oh, that doesn't matter. You can invoke our judicial system, our judicial processes, because they're collective, and I understand they are different because they're collective. But what's the policy underpinning for the difference when you, in both cases, are just trying to use our justice systems on the basis of a foreign judgment? I know you're dying to say something.
Yeah, I'm dying to say something, but that is because, on the one hand, you're enforcing the debt. You're enforcing the judgment, sorry.
Yeah.
You're enforcing the judgment. And the steps you're taking are based on the judgment.
Yeah.
And in order to do that, you have got to either have it recognised or you've got to get an English judgment. The other step is about you being a creditor. And the fact that the liability arises under a judgment is different in the sense that you are not coming along and enforcing that judgment. You are enforcing the debt. So suppose we had a trade debt due in Russia, for example. No judgments involved, just a trade debt, and we're a creditor. And we establish that we are a creditor. So we come along to this country and we invoke this country's insolvency regime based upon the fact that we are a creditor. The only difference is that what establishes our status as a creditor is a foreign judgment. What I'm not doing when I'm a trade creditor is I'm not coming and executing on a judgment. That's a different thing altogether. I am a creditor, and it makes no difference. The fact that it has arisen under a foreign judgment makes no difference. If I'm a creditor, I can put my debtor into the English insolvency procedure. And why would it be the English insolvency procedure? Well, in this particular case, because Mr. Drelle is in England. But it is different, my lord. It is different. I'm not executing this judgment.
But why do creditors bring bankruptcy proceedings? It's because, isn't it, they hope and intend that at the end of the process they will recover, at least in part, the debt that entitles them to bring them.
Yeah, but most forget, apart from anything else, motivation's got nothing to do with it. I mean, what advantages a creditor sees in a bankruptcy process?
Well, it has this to do with it, doesn't it? I say motive. That is in part what the system is designed to engender. I quite understand the fact that it's exercising a class right for everybody and so on. But at the end of the day, someone who brings bankruptcy proceedings is employing a process which can enable them to recover the debt or part of the debt, which is what entitles them to commence the process. Is that not right?
That may or may not be what comes out of it. It may or may not be a motive.
But actually,
the
wait a minute.
law is...
Sorry, I'll go in support of my law. If it's not your intention to pursue your right as a creditor, it's an abusive process.
Yeah, no, I'm sorry, my lord, no. Because a creditor is entitled ex debitate justicii to a winding up order or a bankruptcy order. We're entitled as of right.
No, but if you are you may say you're entitled to the right, but if you are, for example, even though you are a creditor, if you're pursuing your bankruptcy petition with no intent or desire to be paid, but because you simply want for example, the disadvantage of the person being made bankrupt, so that, for example, they can't stand for public office, which is the relevant authority, then it's an abusive process and you'll be struck out. I mean, that's remored and the cases that decide it.
If I'm not pursuing this bona fide as a creditor, then of course I understand your lordship's point. But my point is, am I bona fide in pursuing my right as a creditor and obtaining what I'm entitled to ex debito justitiae? What exactly I might hope comes out of it, it may be that there are cases in which it's entirely collateral purpose. It may be. I completely take the point, but it could be an abuse.
I think all my lord was putting to you that it must be an inevitable part of a creditor's purpose when pursuing a bankruptcy petition that they want to have their debt paid.
Yes. No, I understand that point. But the one thing that one mustn't confuse is it's another way of executing the judgment, because it isn't.
Well, I think I was picking up my lord's point. Why should there be any difference in principle between all the other forms of execution, which you can't do with an unregistered or unrecognised judgment, and bankruptcy proceedings, in circumstances where the underlying nature of bankruptcy proceedings is and has to be, in part, to recover, which is the same underlying basis for execution properly, so-called. That was all I was really seeking to tease out and see why is it different in that respect?
It's different because they are different mechanisms that do different things. They're different rights, they're different mechanisms. The right to enforce depends upon there being a judgment. The right to bankrupt or wind up depends upon there being a debt. They're different.
Can we take stock a moment?
Oh, I'm
We've
so
obviously
sorry.
got to 1 o'clock.
Yes, I'm sorry.
How much longer are you on ground one? Do you think?
Well, first of all, I apologise. This is taking me
No.
far
You've had lots
longer.
of interruptions, but can we just work out what really matters on ground one, because you've got to get through
Well,
the other
what I
grounds.
want to do is, what I want to do now is the textbooks. I've got 3 textbooks.
Yes.
That won't take too long.
Yes.
I was then going to move on to the grounds for impeachment.
Yes.
And
So those are the other grounds. No, you're not.
Well, the case that really matters is Maximov. That's the case that really matters, and that gives your lordships where you get to the threshold. The point that I can take quickly is I do want to show you the Russian judgments, because I don't think you've really had an opportunity to look at them yet. The points that I can take quickly are what I would call the Zaglova Russian law, and if you'll bear with me, I will try to take those very, very quickly.
And that makes sense. Mr. Semek obviously needs a little while to
No, I
reply.
understand.
I mean, replies in this court tend, for good reason, to be very short. But even so, I think you've got to manage your time so you're sitting down by 4 o'clock-ish.
No, I completely understand, and I really do apologise, because I thought I'd be a lot quicker.
I'm not sure that that's entirely down to you, Mr. Phillips.
No, it is. It's my job. So,
although it's 1:05, we'll start again at 2.
thank you, my lord.